Hey everyone, and welcome to This Explainer. I'm your host, and as a peer mentor to all of you final year law students out there, I know exactly the kind of pressure you're under right now. I mean, contract law can feel like an absolute maze, right? It's just full of ancient terminology and overlapping theories that you're desperately trying to memorize for your exams and your thesis. But don't worry, today we're going to completely cut through that noise. We are going to master contract law together, bridging the gap from foundational domestic theory all the way to the gritty realities of complex cross-border corporate disputes.
Okay, let's dive into this. Here is our blueprint roadmap for today. We'll start with the basic foundations, move on to valid contracts, then the principles and norms, look at international jurisdiction, and finally, put it all to the test with a case study from SIAC.
All right, kicking things off with Section 1, the basic foundations of contract law, bridging the basics.
Now, before we can even think about analyzing complex international cases, we absolutely have to clear up a fundamental academic confusion. Law students constantly, and I mean constantly, mix up these three concepts: legal obligation, agreement, and written contract. While they might sound kind of similar in everyday conversation, they are distinctly different in the legal hierarchy. The crucial thing to remember is that an agreement is the actual action that creates the legal obligation. The obligation is just the result. And what about a written contract? Well, that is simply the physical, written form of an agreement. While all written contracts are agreements, not all agreements are written contracts. They can be entirely oral. And keep in mind, agreements are just one source of legal obligations. You can also get obligations directly from the law itself or from judicial decisions.
And this brilliantly illustrates the whole breakdown. Looking at the hierarchy, we have general events right at the top, which then branch down into legal events. From human actions, we get obligations. Notice how agreements branch out from there, and only underneath agreements do we finally find written contracts sitting right alongside oral ones. It shows exactly where written contracts sit within the broader legal ecosystem. It's basically a subset of a subset. Seriously, burn this visual into your memory right now. It will save you so much confusion during your oral exams.
Moving right along to Section 2, Requirements for a Valid Contract. Let's look at the 4 pillars of validity.
So, what actually makes a contract legally binding under Indonesian law? For this, we turn to Article 1320 of the Civil Code, or KUH Perdata. It lays out 4 absolute requirements. First up, consensus, meaning a totally free agreement between the parties without any coercion or fraud. Second, the legal capacity to make an agreement. Basically, the parties have to be of legal age and of sound mind. Third, a specific subject matter. You have to clearly define exactly what is being promised. And fourth, a lawful cause, meaning the purpose of the contract absolutely cannot violate the law. I've got to warn you, missing any single one of these completely compromises your client's position down the line.
Now, what's really interesting here is how we categorize these 4 pillars and the incredibly severe difference in juridical consequences if they fail. We split them up into subjective and objective conditions. Consensus and capacity are subjective because they relate directly to the human parties involved. If these are flawed, say someone was actually underage, the contract is considered voidable, or vernietigbaar. It actually remains valid right up until a judge formally cancels it. On the flip side, a specific subject and lawful cause are objective conditions. If a contract involves illegal activities, it lacks a lawful cause. The consequence? It is null and void, nietig van rechtswege. Legally speaking, it is considered to have literally never existed in the first place.
All right, let's shift gears in Section 3 to the principles and norms of agreements. These are essentially your rules of engagement.
So we're moving from the strict technical requirements to the underlying principles that dictate how parties actually have to behave. The absolute bedrock principle here is pacta sunt servanda, which you'll find in Article 1338 of the Civil Code. It essentially states that every validly executed agreement is as binding on the parties as the law itself. It's all about providing legal certainty. But here is the kicker. It must be performed in good faith, or itikad baik. You absolutely cannot just follow the strict letter of the contract while maliciously undermining its spirit or taking unfair advantage of the other side.
Let's move to and see how this builds in a practical, real-world domestic case. Sinta versus PT Jayapura. On paper, the contract stipulated a standard 8-hour workday, which, is perfectly legal. However, the reality on the ground was a very different story. Sinta was forced into 12-hour shifts with 0 clear overtime pay. While the contract technically met the formal requirements, the company's execution completely violated that principle of good faith and the principle of balance. Always remember, freedom of contract is not absolute. It is hard-capped by mandatory public laws. Any clause or corporate practice that violates mandatory labor laws becomes null and void immediately, and the statutory legal protections for the worker automatically kick in to take over.
Okay, time to zoom out the lens for Section 4, Contracts and International Jurisdiction. What actually happens when our contracts cross national borders?
When we talk about international law, we have to distinguish between two totally distinct spheres. Public international law deals with state-to-state relations. Think sovereign governments signing massive global treaties. But for us corporate lawyers, we focus on private international law, or HPI. This applies when private non-state entities, like say a corporation in Indonesia and an oil company in South Korea, engage in cross-border agreements. It is private entity to private entity, but because it's operating across national jurisdictions, it introduces a whole new layer of complexity.
In these international corporate contracts, parties generally have the autonomy to choose which country's law will actually govern their agreement. We call this the choice of law doctrine. However, this autonomy is not a blank check. It is strictly limited by local public policy. A domestic court simply will not enforce a foreign law if it blatantly violates the fundamental justice or the mandatory rules of the home country. Furthermore, when disputes inevitably arise, courts or arbitrators are going to look for a real connection, a nexus, to determine jurisdiction. You can't just randomly pick the law of a completely unrelated country if it has absolutely zero connection to the parties or the commercial transaction.
Which brings us to our final stop, Section 5, Case Study, SIAC 2023. This is the crucible where we put all this theory to the test.
So the crucial point is seeing how all this applies in a high-stakes scenario. Let's look at the facts of a massive 2023 arbitration case. The parties involved were PT Nusantara Marine Equipment, an Indonesian company, and Blue Wave Shipyard Ltd., a South Korean company. The chosen forum for dispute resolution? The Singapore International Arbitration Center, or SIAC. Yet the governing law they explicitly chose in their contract was Indonesian law. This is a classic, complex mix of jurisdictions and an absolutely perfect example of private international law in action.
This case perfectly demonstrates that concept of real connection we just talked about, and how arbitration seats actually work. Notice the strong nexus to Indonesia here. The seller is based in Surabaya, and the goods were physically shipped from the Tanjung Perak port. This massive real connection entirely justifies the application of the chosen Indonesian law. But wait, what about Singapore? Well, Singapore was simply the seat of arbitration. That just means the arbitration procedural framework falls under Singapore's International Arbitration Act, which provides limited judicial supervision. SIAC merely administers the process itself. The substantive law resolving the actual underlying dispute remains Indonesian. It beautifully showcases how party autonomy, real connection, and international arbitration all intersect in the real world.
To wrap up our explainer today, I want to leave you with a provocative thought. And honestly, this is absolutely perfect for those of you currently brainstorming thesis topics. If a multinational corporation drafts a cross-border contract and strictly chooses a foreign law specifically to bypass and avoid mandatory domestic labor or environmental regulations, how exactly would you use the doctrine of public policy or a ketertiban umum to strike that choice of law down in court? Really think about the limits of party autonomy there. Understanding these deep, complex layers is exactly what will elevate you from just being a law student to becoming a true master of contract law. Thank you so much for joining me on this explainer. Keep studying hard for those finals, and I'll catch you in the next one.